Let's start the next edition, or welcome to the next edition of the AICZECHIA seminar. This time, again, it's going to be fully online, and it is a real pleasure to welcome today here with us Radim Polčák, who is the Vice Rector at Masaryk University and Head of the Institute of Law and Technology of the Faculty of Law of Masaryk University. So the topic will be a little bit unusual today, but it's very exciting. He's also a founding fellow of the European Law Institute and the European Academy of Law and ICT. He's general chair of the Cyberspace Conference, the founder of the Masaryk University Journal of Law and Technology, and has contributed significantly to the development of legal regulatory framework of Czech and European cybersecurity, and in 2017 and 18 served as a special advisor to the European Commission for Robotics and Data Protection. So he's national expert for the Czech Republic in the Global Partnership for AI, which is an organization many of you have heard about, and is also a member of the Legislative Council of the Czech government. So Radim authored and co-authored over 150 scientific papers, books and articles, especially on topics related to cyber law and legal philosophy. So today he's going to talk about regulating AI, compliance, liability, and rights to data. And as usual, we'll aim for a 30-minute presentation, which is going to be recorded, followed by a 30-minute discussion on this topic. So Radim, thank you very much again for coming here today, and the stage is yours. Thank you.
Thank you for having me. It is a very unusual topic for this audience, and it is a bit difficult for me also to summarize the past, I would say, like 15 years of my research into this summary that should address the most relevant regulatory issues in AI. And first of all, sometimes when we discuss with computer scientists and people from mathematics and from natural sciences, then they tend to speak about legislation and they mean law. Law is not just the legislation, but of course, in Europe, legislation is the core of our legal system. These are all those statutes and acts and all those legislative instruments like regulations and directives. So when we look at the legislative situation that we have, it is relatively complex. And here I listed not all, but some of the regulatory instruments that are relevant in relation to artificial intelligence. Although in law, we do not really know what artificial intelligence is because there is no uniformly accepted definition. And now we mostly debate the AI Act and AI Liability Directive.
Radim, can you share your screen, please? Because it seems it's not shared.
Is it not working?
I think it is.
It is shared.
Yeah, there are all these boxes all around.
Do you see the bubbles popping up?
Yes, yes.
Like this one, yeah.
Yeah.
So, but it's this. I do not have as much text on the other bubbles as on this one, but here I wanted to list at least some of those regulatory instruments that we have, apart from those main elements like the AI Act and the AI Liability Directive. There is the GDPR that already contains a lot of provisions that affect machine learning-based systems. There are other instruments on data, etc. So I will try now to sort it out to three main regulatory issues that we deal with in law, and these are the ways in which anybody who has something to do with AI should approach the regulation. So it is not entirely necessary that everybody reads all these legislative instruments and all the literature from all the directions. But I think it is just enough if we understand the regulatory agenda through these three main areas. One is compliance, that means ex ante regulation. So that means conditions that have to be met before something is put or something is deployed. So these are all these compliance duties and all these certifications, etc., that some product or some service has to meet when it enters the market. Second item is liability, and that is all the bunch of laws that relate to situations when something bad happens, and then what is the consequence. So here we ask, so if there is some autonomous system and it causes some harm or some damage, then what are the legal consequences? And then, of course, shapes also the development and deployment of that system, but it is a bit different type of regulatory agenda from the legal perspective. And the third element that is quite neglected in the recent debate, because we debate the AI Act, which is primarily about compliance, and secondly, we debate the AI Liability Directive, that is about liability, obviously, and we sometimes neglect the third element, and that is the rights to data, because when we use data for machine learning, then there are various rights that protect this data, and it is not just personal data protection, it is also intellectual property rights, it is sui generis rights, it's different types of rights that we have here in Europe, and that also heavily affects the way in which AI systems are developed and deployed, because this data, they're absolutely essential in order to develop the system and then in order to let it evolve. So these are the three main areas, and I would like to briefly tackle them, and then we can discuss about whatever you find interesting. Now, first things first, the AI Act. Now it's stirred a lot of debate. This is the last version. It is not a public document. This is what now circulates, and that is the result of consensus in the CoReper, and now it will go to the European Parliament. It is about ex ante regulation, so about all these compliance duties. And in this draft AI Act, the systems that are based on AI are divided into three groups. It is everything which is using some kind of AI as a basis of its functioning. Then there are high-risk systems. This is Professor Mařík calling. Sorry, I'll put it down. He should be at the seminar, by the way, because it's AICZECHIA organized. Anyway, I'll call him later. So it is all AI that is under some regulatory conditions. There is high-risk systems, which are specifically designated either by the Act, or it is envisaged that the European Commission will designate high-risk areas. And then the third is forbidden applications of AI that are directly forbidden, and it is implied by the law. Now, I was first skeptical about regulating more AI systems because there is horizontal regulation of technology, and I didn't like it. But then we had some talks in high-level expert group that we were asked to put together by the Czech government, and it was consisting of international experts. And mostly their approach was relatively open to this horizontal regulation. And I kind of got persuaded by this approach, but under the condition that this horizontal regulation is inclusive. So it does not pose exclusive requirements that would exclude some technology from the market. I mean that if these regulatory duties are limited just to very minimum adherence to some very general principles, and designating these AI-based systems or labeling them, then it doesn't present any burden for anybody to enter the market. And then it should be in general quite okay, and it should just inform the consumers that it is something else than what they are used to. And at the same time, it should somewhat motivate the researchers or the providers of these systems to think about these very general defined principles. So as long as it is inclusive, I think it can be horizontal, and then it is okay. And then we have these sectoral regulations for high-risk systems. And there, I think that the approach is correct. The only question is what will be designated as high risk, and what is the legitimate aim of this high-risk designation. Originally, this was meant to be evidence-based. Now, if you look at the recent drafts and at the explanatory memorandum, it changed so it will be risk-based. And we will have to carefully assess whether there is really sufficient risk in order to designate something as high risk. Because when it is designated as high risk, there will be required certification, and the certification will be costly, and it will be time consuming, and it will represent a burden of for these products or systems to enter the market. So we have to be very careful, and we have to observe where the Commission will look, and there should be, in my view, better mechanisms of preventing the Commission from totally politically deciding about it. And then there are forbidden systems, and there are designated the forms of use of AI that are totally forbidden and that are unacceptable in terms of protection of values that the European Union is based on. I'm entirely okay if public use of social scoring systems is forbidden. What I'm not entirely in line with is this facial recognition or this biometric recognition systems being used in public places. I don't think that it's a good idea to ban them as such, but that's about political debate, and we should leave this for politicians, and there we should have some political decision. Now, what I want to point out in relation to this AI Act, and what is very often misunderstood, is that these rules are performance-based. That term is used, and it's a relatively novel way of regulation. And very often, these rules are defined in the way that the state doesn't say precisely what has to be done. So there is no one single best solution of the regulatory problem. But the performance-based rule is designed in a way that there is set some general requirement, and the regulated subjects, in this case, it will be providers of AI, decide about how to develop their own rules in order to adhere to these generally defined principles. The best example that I use is the difference between speed limits on Czech highways and German highways. On Czech highways, we have the speed limit of, I believe, 130 kilometers per hour. On German highways, some people think that there are no speed limits, but there is actually speed limit on German highway. You can drive as fast as it is safe. So everybody has a duty to set his or her own speed limit. And that is exactly performance-based rule. So you should know what kind of driver you are, how good car you have, what is the situation on the road, what is traffic like, what is, I don't know, weather conditions, etc. And nobody is in better position to assess how fast you can go than the driver, because only the driver knows the situation, not the state. So this is something similar, and we have these performance-based rules already in the GDPR, for instance. We have it in cybersecurity. We had it before. We have it, for instance, in fire prevention or in some other fields. But it is being extended, those fields where we use these performance-based rules. And the point is that there is no one single answer to these regulatory questions, like how should we do it? It is because there are different ways how it can be done, and it provides the space for those who develop and deploy these systems to decide how they protect the relevant rights at the best, and then to document it and to implement it. So this should be understood, and this, I think, is of crucial importance. So that's the ex ante regulation, that's the compliance. Now, the second stage or second part of the regulation is liability. And that means rules that define what happens if something goes wrong and if some harm or damage is caused. Here, there is the draft of the AI Liability Directive, which should not be a regulation, it should be just a directive. And there has been a long way to it. First signs of this issue have been highlighted by this resolution of the European Parliament. And the European Parliament was, for a relatively long time, quite interested in regulatory issues in artificial intelligence. This was actually the second resolution of the European Parliament. The first was, I believe, in 2015, 2014. So there's steady agenda at the European Parliament in this. And then there was this staff working document by the European Commission that highlighted some of these liability issues. And if I should recommend now some relevant publication that summarizes all these issues and that can act as a compendium for AI liability, then it is this. It is not always the best what the European Parliament produces in terms of quality, but this is really a good compendium, and you can Google it, and it is freely available on the internet. I even use it as a text for our students and our PhD students, because this really is summarizing these issues that we have in the liability. Now, if I should summarize them very quickly, then first thing is that this AI liability is not about definition of new liability titles. It means we are not going to define new types of harm or new types of damage. Harm will still be the same, so it can be physical harm, it can be harm to privacy, it can be harm to intellectual property rights, it could be defamation, it could be other areas that we already have defined in our laws. And so we are not creating new titles. What is of an issue for specific regulation is the second question: who is liable? Because we have multitude of stakeholders. So if there is a system that is deployed, then there is always some developer, and that developer continuously contributes on the development of the system, even after the deployment of the system. Then there is somebody who provides data to the system. Then there is somebody who provides infrastructure or some other kind of framework. And very often it is a very complex situation when there are multiple stakeholders. Now, if I take it through the perspective of the Czech law, if there is some system and it causes harm, and I do not like to use that example of autonomous cars, because these autonomous cars, that has been a big topic, and we have been investing into autonomous cars, and everybody has been driving in autonomous cars for already 15 years. And now it turns out that we will probably never have autonomous cars on the level 5 of autonomy, and even the big car producers are now saying that probably the future will never happen. But let's say we can use it as a didactic example. So if there is an autonomous car and it causes harm, then there may be multiple stakeholders that contributed on the fact that the car hit something and caused some harm. And under the Czech law, all these potentially contributing stakeholders are liable at the same time. So there is something that we call solidary liability. And that means that if you have standard situation of companies that develop this and provide data and provide various sorts of services to those systems, then they would need insurance, because there is always like this general insurance that you have to have if you are a business or a corporate unit, and if you do business. Insurance for just doing that business. And insurance companies, they do not have models calculated because it is very difficult. There is no experience. If we have experience, then it is easier to calculate insurance models, but here we have very little experience. The only experience that we have with robots is from production halls where robots are used to make cars or whatever, and from time to time there are accidents and insurance covers it, but there is totally different situation compared to when these autonomous systems will be released to the general public. And that's why these insurance products will inevitably be expensive. Now, when we had debates, and when I served at the European Commission, we had debates with various stakeholders from the industry. And that was during the Juncker Commission, so that was many years ago. And we thought, because the Commission needed to define its basic regulatory policy, and we thought that we would talk to those stakeholders, and everybody will be offering some kind of input, these lobbyists. So somebody will be lobbying for financial institutions, somebody else will be lobbying for, I don't know, manufacturers and all the service providers and telecommunication companies. And then we will sort it out and we will say, this is the way in which we can go. And we thought that we will get this very particular input. But what we got was just the claim, like, make it simple and predictable and point to one entity that will be liable. And then the business cycle, the business mechanisms will sort it out. At the end, it will always be the user who will pay the cost. But the idea is not to make it too costly at the end. And if everybody will have to get this expensive insurance, then the costs will be outrageous. While if there is just one entity that will be designated as liable, then it can be easier, because there will be this expensive insurance, at least at the beginning, but it will be paid just by this one subject. In cars, it is relatively easy, because if you like to release a car to the road, then it needs to have a green card, and then it's always an insurance, and then it is linked to the owner of the car. So similar thing, that was the basic claim of the industry. So that's one basic issue, like who can be liable, and to make it clear and predictable, and at least to narrow it down to a limited amount of subjects. And secondly, the burden of proof, or how to prove the fault or defect. Now, this seems an easy thing, and we had these cases of these not entirely autonomous cars, but cars in some kind of autonomous mode crashing into something, and then it's being investigated. But you are experts, so you know about the problem of explainability. and explainability of these autonomous algorithms. And if I take it from the product liability perspective, if you'd like to claim product liability-based damages, then you need to prove that you have faulty product and you need to prove the fault. And now we have experience from software-based systems, any kind of software-based systems, from computers to cars to anything, from past, I don't know what, 3 decades. These systems were programmed by humans, so these algorithms are readable and we can assess them and we can find bugs in those systems. And even in this situation, we didn't have cases where claimants would be successful in proving fault in these algorithms. So my prediction is that it will be even more difficult when these algorithms are not human readable, or when these algorithms have this issue of explainability. So, because we didn't have cases, or we didn't have almost any means of proof that would be sufficient to establish faulty software in the past when the software was explainable. And even more, I expect that would be a very difficult issue now. So what this draft is trying to do is to establish some basic rules for liability, and it is just fault-based liability, which is quite problematic because it doesn't cover IP or defamation. It covers really mostly this physical damage. It speaks about providers who should be liable, so it narrows down the situation of the multitude of stakeholders just to be providers. Plus, it establishes something which we call in law the burden of proof. So who should prove it? And it switches, in general cases, the burden of proof. So if damage is caused, then the damage party doesn't have to prove who caused the damage and where was the fault, but it will be the provider that will have to prove that there was no fault in the system. Now, proving will be extremely difficult. So I bet that whoever in this game will have the burden of proof will lose the case, because it will be very difficult to prove on either side. But it is not just general switch of the burden of proof, because it can be switched back if there is some certification. So it will represent a complex situation. But to me, the solution would need more refinement, because it's one party or the other party. And really, I think who will be under the burden of proof will lose. And it shouldn't work like this. It should be more refined, and it should be more like tuned for these situations that we can envisage. And the last point is rights to data. And we have multiple rights to data. And again, here I have a bit more text than I would like, but this is the list of some rights that we have to data. And if you are developing a system that uses machine learning, then you need to have source data. And these data are protected by personal data protection, by privacy protection, which are two different things. Sometimes we tend to think that it's one and the same kind of regulatory system. No, these are two entirely different systems of law. Personal data protection is European, privacy is always regulated on the level of the national member states, and personal data is more administrative and privacy is more private law. There's copyrights, there's sui generis rights which protect databases, there's trade secrets, there's trademarks, there's personality protection, and this personality protection is extremely interesting in terms of chatbots, for instance, because we have cases when some company hires people to chat with consumers, then chatbot learns how the person is chatting, and then the person is kicked out, but the chatbot is kept. And the chatbot learns on the personalized pattern of how that person communicates. And sometimes these companies even retain the photos of these actual people. So the consumers, they think they are communicating still with the same person, but the person is already fired and has no income from the fact that his or her personal pattern is used for the robot. So that is also something which is protected by the personality protection. And that is a multitude of rights. And moreover, we do not have harmonization across the common market. So if you'd like to develop machine learning system on the common market, you need to clear all these rights, and many of them you have to clear case by case in individual member states. Some is easier because we have harmonization in the GDPR, for instance, so personal data protection should be a bit easier. But some you have to do the clearance like on case-by-case basis. Now the question is how to deal with it. We do have several options. It can be dealt with either by harmonizing the European legislation in more fields or in all the fields of rights to data. And it is something which is not commonly known, but we have common market in potatoes or coal, but we do not have common market in movies or music. And that is a paradox that it's difficult to understand. Well, there are very strong lobbying calls from the member states and from distributors, etc. That's why we don't have it. But there is no reason why we don't have one single copyright title or one single sui generis title across the European Union. But that's for another debate. So harmonization is one of the tools. And the second tool, we should choose. Either we will accept that we will have less rights, or, and I would not recommend this, because in Europe, there is no place on earth where people would have that level of protection of fundamental rights as we have here in Europe. And yes, it is complicated and messy, and we need expensive lawyers for everything, etc. But still, the standard that we have here, and we do not recognize it, but it really is like that, is unprecedented anywhere else in the world. And you can forget about the United States. The level of protection of fundamental rights is totally different in Europe and even in the United States, that's the closest to us. Not to speak about countries like China or I don't know, so even some worse countries. So I would not recommend to decline the level of protection or to limit the scope of rights or whatever. That's probably not the way. The way is to develop mechanisms that will make it easier for these rights to be transferred. And here we do have various solutions. And one of the options is something which is called data trusts. And these are entities that aggregate the rights. And it can have corporate entity or doesn't have to be corporate entity, doesn't matter. But it could be like a trust that is consisting of 1 million people, and all their rights to their data are formed into one like pile. And then if you like to do development, machine learning or whatever over these rights, then you need just to have one agreement that is transparent and easy to get. And then it can also assemble these rights from multiple member states. And this can solve the problem of multitude of regulatory regimes across the common market. So that, I believe, could be the solution. And this is where we should aim also this public investment. So far, the Commission has invested into promotion campaigns, like advertisement campaigns that say GDPR, it's easy, you can do it. Instead, I would like be more in favor of development of these standard instruments like typical contracts or these types of establishments like these data trusts. And last example is, and that relates to these data rights, that is from the United States, and that is this recent case of GitHub. Some of you have noted it, and that is about using copyrighted data for machine learning. And this case is now pending at US courts, and we will be following it. In Europe, we do not have this problem that bad because we already have this legislation that is a part of the Digital Single Market Directive. And there is copyright protection exemption and here it is set for data mining, but this data mining, it should be understood really broadly, and it could also cover machine learning. So we should not have this issue here in Europe, but it sparked the debate, like whether there should be copyright protection on data that are used by some machine learning system. And I know that mostly in this community that is represented here, there is fury about this tendency to copyright protect the source data that are used by these machine learning systems. I wouldn't say that it is so easy and so straightforward because this machine learning system, it does represent an added value, but there would be no value if there is no source data. And if somebody invested into the production of the source data, and that's the idea of the copyright law. And I'm not a big friend of copyright law. I'm rather on the side of that the copyright law should be left for history. But the basic idea of copyright law is relatively fair. If somebody invests into the creation of copyrighted content, then if this copyrighted content brings money, then there should be some transfer to the person who has invested into it. And that works for AI systems, that works for internet search engines or whatever. So we will see. If you'd like to read something about it, there's a very nice article on SSRN by Daniel Gervais, and it maps the current development. But that is just an example of one of these rights that enter into this situation of machine learning, and that can make it difficult. But we can clear these rights. I would not recommend to limit them too much, because then we could lose these rights in general, and that, in my view, is not advisable. So that is my very brief, basic overview of this regulatory agenda. And now we will see what was of any interest of any participants. Thank you.
Thank you very much, Radim. That was great. Thank you very much. So we will move to the question part. So Honzo, if you can stop.
I'm stopping the recording. Yeah.